Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. This week we're talking about copyrights, and this episode we're talking about copying. Don't copy content. That's words, images, video, music, etc. until you listen to this episode. So the song Happy Birthday to You is not just the world's most popular song. It was also under a copyright claim for many years. There was a lawsuit that resulted in an order in 2016 that was issued by a court placing the song into the public domain. This case highlights the importance of understanding copyright law and verifying the public domain status of any copyrighted work before using it in your business. It is crucial to protect yourself from potential lawsuits and penalties while also ensuring that you are not infringing on the rights of others. Copying is copyright infringement when there is a copyright on what you're copying. I know that was a lot of copies in there. Let me try to restate that. Anytime you copy, even if you modify or create new material based on what you copied, you are at risk of copyright infringement. And so there's definitely some defenses that people might think will work. One might be, well, everybody is doing it. So if you see lots of websites using the image or a drawing or a song, they might all be licensing the copyright. They might all be infringing on the copyright, or the material might be in the public domain, or somewhere in between. So the term of copyright protection, how long it lasts, it's important to understand so you understand how far you have to look back. Now, in looking back, the term of copyright has changed over the years, but the current copyright, if you apply for a copyright today, then the default rule is that it's for the life of the author plus 70 years after the author dies. If it's owned by a corporation or a few other reasons, it might be 95 years after the work is published. So just because it's old doesn't mean it's in the public domain. Don't copy without permission. So what is copying under copyright law? Copying is taking any part of a copyrighted work, even if you modify it, distort it, redraw it, add significant original content, and if you plan on using the work of others, make sure you obtain permission or a license to use their work to avoid copyright infringement. Now, this isn't necessarily a black and white case, but let me explain. When you copy, even if you are transforming it, there is the risk of being sued for copyright infringement. Now, there is a defense that lots of people have heard about called fair use. And it's actually a very limited defense to copyright law. And one of the problems with relying on fair use is that it's a defense after you get sued. You can still get sued, and the court says, okay, you copied, but was it a fair use copying? And you have to convince the court that it falls under the fair use exception. That means attorney time, lots of cost, time, headache, stress. Let me get a little further and deeper into the fair use so you get a better idea of what I'm talking about. The fair use doctrine in copyright law, it's a case-by-case analysis. They focus on 4 factors. And in the law, when we say factors, that means one of them, if it's strong and the rest of them are weak, the court could still decide, well, because that one's strong in favor of one party, we're going to rule that way. Even though 3 other factors ruled the other way, it's kind of a gut feel in a lot of ways. So that's why some attorneys are focused on litigation, because they're good at convincing people based on and getting them to get their gut to feel something. It doesn't always work, though. So here are the 4 factors. Factor 1 is the purpose and character of the use. If it's commercial, it's probably not going to be fair use if you're making money off of it. Fair use for this factor, it's really set up to favor news commentary and nonprofit education. So that's the first factor. And with so non-commercial and transformative uses are more likely to be considered fair use, but it's not a blanket rule. So if you transform the work significantly, that's going to be in favor of fair use. So the next one is the nature of the copyrighted work. And so if it's highly creative or imaginative work, like a novel that's just, whole world is created by an author, then it's going to receive more protection than a factual work like an encyclopedia, if my listeners know what that is anymore. So if it's fact, and really what it comes down to is how creative is the content. The more creative it is, the less likely copying is going to be considered fair, or under the fair use doctrine, which is the exception or the get out of jail free card. The third factor is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And it isn't always necessarily what portion, but how much of it. And there's no specific rule. There's no specific amount that you can be using and, be considered fair use. But they weigh that in the balance. And the fourth and final factor is the effect of the use that we're claiming is fair use upon the potential market for or the value of the copyrighted work. For example, there was a case where a publication, a newspaper, I think it was, published significant portion of a chapter of a book. Now, the author of the book sued and said, and when they said it was fair use, they said, well, that is the chapter that people buy this book for. So by you publishing it, you've gutted my ability to sell this. And so there's no set formula. There's no way to determine ahead of time, absolutely, you're safe in fair use. You have to go through a legal battle to find out if it's fair use. A lot of cases do settle out of court, but that's usually, someone's taking a license, and the license is usually going to be cheaper up front. A lot of these cases, though, artists have decided to go forward after they asked for permission and were denied. And sometimes they get what they want. Some of the songs that became famous that were considered infringing use, they made a name for the person who infringed. And, that person became famous, and that was part of what they wanted. So I'm also going to cover real quick. You need a license for most open source content. A lot of content is available for free use if you follow the rules. So open source content, whether it's software code or a photograph, it'll have a license attached to it with limitations of that license, such as attribution, commercial use, and whether or not you can create derivative works. And you'll see this, there's an organization called Creative Commons, and they've created a set of licenses that people can attach to be able to give away for free with limitations. Like, I'm going to give this away for free, but you can't sell something. You can't put this on something and sell it. Like, you can't put it on t-shirts or mugs or mouse pads and then sell it. If you want to do that, come talk to me. I'll, grant you a license. We'll figure that out, but it's not under this free license. So if you are using music, videos, pictures, or images or other artwork in your business, it is essential to verify that you have permission to use the work or that the work is in the public domain. Once you verify you have permission, you need to keep a file that links the content to the place you obtained permission. If it's in the public domain, you want to list how you figured out it was in the public domain. If you're using your own original works, you want to list in your file, like keep a spreadsheet that says this is our original work. Here's who created it, and they're an employee, or we have an agreement with them. And licensed works, you want to, oftentimes there's a link to the license or something you can notate that shows where the license is. So it's important for you to understand that copying is a risk, and it's a risk you can manage, especially if you take licenses, if you set up systems so that you know that whatever you are putting out there is either licensed or original content that you created. So the next episode, we're going to go ahead and talk about qualifications for copyright ownership. And this gets into ChatGPT, OpenAI, and whether they can get copyright, what the courts have said so far, and kind of where we're at with that. I'm Wayne Carroll with Leveraging Inspiration. Thank you for joining me.